the amazing saga of the Supreme Court vacancy and the repercussions thereof. That story continues, and here to help us understand it now is Ian Millhiser. Ian is a very distinguished attorney in his own right. He is also senior fellow at the Center for American Progress Action Fund. He is the editor of Think Progress Justice, and he is the author of the book Injustices, the Supreme Court's History of Comforting the Comfortable and Afflicting the Afflicted. Ian, thanks so much for joining us.
Thanks for having me. Thanks for the book pitch as well.
Always. And listen, this Supreme Court story, in my view, continues to amaze. You've written a couple things about it. One is on Mitch McConnell's position, not only that he's willing to threaten that, rather that he's saying that he will block the current president's nominee from coming before the Senate for consideration, but apparently he is extending that threat potentially into the future as well. Is that
Right.
true?
Yeah. So Senate Majority Leader McConnell was asked, because his talking point throughout this whole saga has been, we need to let the American people decide and let the next president choose the next Supreme Court justice. And so he was asked, well, okay, when the next president is elected, will you guarantee that person an up or down vote on their nominee? And McConnell said, no, he wouldn't guarantee that. So, what's going on here is not that Mitch McConnell has some principled stand about when a vacancy should be filled. His stance is that he doesn't like this president. He doesn't want this president that he doesn't like to fill a seat on the Supreme Court. And if in a year we have a different president and he doesn't like that president either, he doesn't want that president to fill the seat either.
So this is something I think maybe the general public doesn't fully grasp yet. Initially, when he said, well, no, his argument appeared to be, well, it's too late in President
Yeah.
Obama's term, which seems to me there's no constitutional principle there, or the
Yeah.
American people get to decide. Well, they decided on the current president twice, so I don't
Right.
know how many times they got to decide on him. I guess the question to begin with that I felt never got asked of the Senate Majority Leader, of Mitch McConnell, was, well, at what point precisely in a presidential term does that president no longer have the right or obligation to
Right.
nominate? Because it seems to make no sense to me.
Yeah, and the honest answer, I think, from McConnell's perspective, is when that president is a Democrat.
Right.
I mean, go back 2 years from now, or 2 years ago. The United States Court of Appeals for the D.C. Circuit is considered the second highest court in the country. It handles a whole lot of really important cases dealing with federal agencies. Next to the Supreme Court, it is the most powerful court in the nation. And there were three vacancies on that court. And McConnell's position, Grassley's position, really the whole Senate Republican caucus's position was that they would not let Obama fill any one of those seats, none of them. And when they were, this is what led to the nuclear option, which eliminated the filibuster for everyone but Supreme Court nominees. The Republicans said they would filibuster anyone, literally anyone Obama appointed. And finally, the Senate had to change its rules to make sure that those seats could be confirmed by a majority vote. If they were willing to fight that hard to keep control of the second most powerful court in the country, well, now we're talking about control of the most powerful court in the country. And they fought that fight over the D.C. Circuit when there were 3 years left in Obama's presidency. So, the problem isn't that Obama has 1 year or 3 year or 7 years or however many years left. The problem, he's a Democrat.
Right. It certainly seems to be the case. That history is very enlightening to me. And in terms of your understanding of the history of the Supreme Court as a body, has there ever been anything like this in history where a Senate leader from one party
Yeah.
decides that a president from another party does not have the right to make their own appointees?
I mean, I could think of two examples, but they aren't examples that paint McConnell in a particularly favorable light. One is Andrew Johnson, who, the accidental president who
Right.
was Lincoln's vice president when Lincoln was assassinated. Johnson was a white supremacist. Johnson opposed Reconstruction. He was doing everything he could to protect or not everything, but like he was doing a great deal to protect the Confederate States and to help them maintain their white supremacist regime. And the Congress refused to confirm Johnson's seat. And not only did they refuse to confirm his nominees, they actually shrunk the size of the Supreme Court to prevent Johnson from putting anyone on it. And so, under those circumstances, where we just fought a war, where there was a white supremacist president, and the white supremacist president was actively trying to preserve the values of the Confederacy. Under those circumstances, the Senate said, we won't allow that person. Also, that person wasn't elected to be president,
Well,
to fill those seats.
and if I recall correctly, before we move on from President Andrew Johnson, wasn't he
Right.
also the one who refused to yield to the authority of the Supreme Court, saying they've made their ruling, now let them enforce it? Am I recalling correctly?
Oh, that was Andrew Jackson.
Oh, I'm sorry.
Who was,
Okay.
yeah,
All right. So never mind
yeah.
that then. I thought that was a telling point, but wrong president.
Right. So, yeah, I mean, the point that I'm making is just that what McConnell is essentially saying with this move is he's saying that Barack Obama is as illegitimate as the white supremacist Andrew Johnson. And that's a simply extraordinary thing for any elected official to say.
It's shocking, really, I would say.
Yeah.
And so, does it surprise you in any way, Ian Millhiser, as an observer of the legal universe and the Supreme Court? Does it surprise you in any way that there hasn't been more of a public reaction about this? Because to me, it's a scandal.
Yeah, I mean, the bad news is that, generally speaking, I think it's hard to get people excited about procedural things.
Mm.
So, the Congress hasn't been working for a while. This is another example of the Congress not working. What I think people have to understand is that their rights are very much at stake here.
Hmm.
So to give just one example, there's a case pending in front of the Supreme Court right now called Zubik. And Zubik involves the question of whether or not a woman's boss gets to decide for her if she gets to have birth control covered in her health plan, if the boss has a religious objection to birth control. So whether a woman's boss, in many cases, is going to get to decide if that woman's going to be able to afford her birth control. And most courts have said, of course, a woman's boss doesn't get to make that decision. But the Eighth Circuit, which is Iowa and Arkansas and Minnesota and a few other states, has said that a woman does not have the right to have her birth control package. Her boss does get to make the decision for her. And so what's going to happen if you have a court that winds up splitting 4-4 is that you can't get a Supreme Court decision deciding what people's rights are across the whole country. When you have these outlier circuits that take away women's rights or someone else's rights, those rulings are going to stand until the Supreme Court intervenes. And we could potentially have a situation where a person has less rights in Minnesota than they do in, say, Pennsylvania.
Which is chaotic, to say the least. It's also an abdication of, I would argue, by refusing to consider an appointment, allow an appointment nomination to go through. It's creating a kind of paralysis in the functioning of one branch of government that destabilizes the whole political process. I mean, the court is supposed to make rulings for the nation as a whole, right? And then we're going to have a kind of limited anarchy if it remains tied like this. I guess the other case I wanted to ask you about, we're talking with Ian Millhiser, who, among other accomplishments, is the editor of Think Progress Justice. I wanted to talk to you about, you've written about the upcoming case of Whole Woman's Health versus Hellerstedt in Texas. And I think the point here is that this was really seen as an attempt to perhaps successfully, under the previous court, kill Roe versus Wade.
Yeah, so the issue here is what are basically sham health laws. So Abortion precedents don't allow a state to limit abortion rights just for the sake of limiting abortions. But they do allow the states, and rightfully so, to regulate the medical profession and make sure that doctors do their job safely and using scientifically valid methods and so on and so forth. And, of course, the state should be allowed to do that. So, what a bunch of states have figured out to do is that they take a law that looks on the surface like it's a health regulation. In this case, it imposes really difficult to obtain credentialing requirements on doctors who perform abortions, and that it imposes architectural requirements and other requirements on the clinics themselves, which are sometimes imposed on surgical centers for various reasons that make sense if certain kinds of surgery are going on there. So on the surface, it looks like these are health laws. But when you dig into them, when you look into the health science, when you look on what what they actually accomplish, they do virtually nothing, maybe nothing at all, to actually improve women's health. What they do in a state like Texas is they shut down the overwhelming majority of the state's abortion clinics. Before this law, there were, I think, 40 abortion clinics in Texas. If this law takes full effect, there will be 8.
Which
So
among other things, would mean that a woman might have to drive for many hours,
right,
and thereby it might negate access altogether, especially in a state like Texas. And you write about the
right,
history of this, which I think is very significant,
yeah,
important. Americans United for Life, a group that has as its intent not the improvement of women's health, but the
right,
elimination of abortion. They've drafted this bill. I think it's important for 2 reasons. One, it proves
yeah,
your point that the bill is not intended to improve women's health. 2, it also, because they draft, they're like ALEC, in that they're a legislation bill. They draft,
right,
what would you call it? Almost prototype bills or template bills that can
yeah.
be passed in many states. So a ruling in favor of this law in Texas would conceivably therefore become a ruling in favor of doing the same in many other states as well, right?
Right. Yeah. Americans United for Life, there's an extraordinarily sophisticated group. They have a bunch of very smart lawyers. And what they do is they look at the court's abortion decisions and they look for creaks and gaps in those decisions, like the one I just described, where a state's allowed to enact health regulations. So let's dress up some anti abortion laws as health regulations and see if the court will say that they're okay. That's what they do. They
Mm.
look for ways to come up with laws that fit in these gaps in the court's abortion decisions, and then having convinced states to pass these laws, then they're often actively involved in the litigation strategy in the court.
So
Um,
they've crafted these to bypass Roe versus Wade in
right.
effect, and they had a chance before Antonin Scalia's death of a successful outcome in the court. Before we get there, Ian
Yeah.
Millhiser, just allow me to vent for 1 second, which is I read your excerpt from their own website that they
Mhm.
say they work through the law and legislative process to one end, achieving comprehensive legal protection for human life from conception to natural death, leaving aside religious views of whether human life begins at conception. I'm going to guess that they're not protecting human life by, let's say, fighting the death penalty
Right.
or ensuring that all people have adequate medical care. I suspect that they are a one-issue group, and
Yeah.
that the hypocrisy of that language just bugs me. I had to get that out. Sorry.
Yeah.
Um,
Yeah, and they state explicitly. I mean, they're very honest about what they do. They state explicitly that their goal is to find these gaps and to move through an incremental strategy towards the day when Roe v. Wade is overruled. I mean, that is their explicitly stated goal. They're very good at it. They're very smart. And when there were 5 conservative justices, there was a very good chance they would succeed. It also means that the question of who fills this seat is extraordinarily important. Because
right.
if that seat is filled by someone like Justice Scalia, if it's filled with another conservative, then we are back in the world where Roe v. Wade is potentially on life support.
And I don't think people understand in this country how significant the stakes are in that sense. I think a lot of
Right.
people alive today don't remember a time when Roe v. Wade was not the law of the land. So I don't think they realize how profound the impact of this could be. Now, what happens, assuming that Mitch McConnell is as good as his word about being derelict in his duty, and we don't have a replacement at all for Justice Scalia for the foreseeable future? What happens to this particular
Yeah.
case and its implications?
There's some uncertainty there. So normally the rule when there's a 4-4 split is that the lower court's decision stands, and it's as if the Supreme Court never heard the case in the first place. If that's what happens here, then the lower court in this case upheld the Texas law. So that means that you get a terrible result for women who want abortions in Texas. There is a chance, however, that they will hold the case over and just not decide it until the seat is filled, in which case there is a stay in place that's keeping that lower court decision from going into effect. So it's this very technical procedural question of whether the court gets rid of the case or whether they hold on to it that could wind up deciding whether or not all these clinics are shut down in Texas.
And in terms of precedent, even whichever way that turns out, we won't really know. There won't be any precedent-setting ruling probably from the Supreme Court until that vacancy is filled. Is that true?
Probably. I should state that Justice Kennedy voted to grant the stay of the lower court's decision and suspend the law temporarily. Kennedy is not someone who's particularly friendly to the right to choose. Before this Texas law, he considered 21 abortion restrictions, and he allowed 20 to go into effect. So he's not if you're pro-choice, he is not your friend. But in this case, he seems to have enough uncertainty they at least voted to grant that stay, and that at least gives me hope that he will, maybe he won't vote to kill Roe here.
Okay. Well, listen, this is a fascinating, if troubling, ongoing set of developments. So I'm sure you'll be continuing to follow it at Think Progress Justice. So Ian Millhiser,
Absolutely.
Senior Fellow at Center for American Progress. Thanks for enlightening us, and thanks for coming on the program.
Thanks so much for having me.